Shalom, everybody. Halalahaya, halalahaya, hallelujah, sha, yashahaya, warawak, kwadash, aman, halalahaya, bahasham, yasha, waharawak, kwadash, Savior, Lord, God Almighty, all praise to the Most High God of IBARAYATH, IBARAYATH, IBARI, YASHALIGHTS, which YASHALIGHTS, the God of the Hebrew Israelites, IBARAYATH, YASHALIGHTS, IBARAYATH, YASHALIGHTS, and we speak Ibari, Hebrew. So demand for discovery and proof of claims. We're continuing on with our video. This is part 3 to Hebrew Israelites in court, concerning law, nationality, and so on. So demand for discovery and proof of claims. Question 1. What is the name, status, and nationality of everybody involved in this case? In other words, what is the nationality and the status and the name of the prosecutor? What the prosecutor. What is the status, nationality, and name of the plaintiff? What is the status, nationality, and name of the judge? Because nationality gives jurisdiction. Status denotes jurisdiction. Name helps you know who is claiming what on it for the record, so you can use it against them. What is the name, status, nationality of the magistrate, the court officers, trustees, and etc.? So ask for the name, nationality, and status of everyone involved in this claim. And do you have a license to be practicing law on my land? So who is the state of Florida and who own it? The state of Florida is not a constitutional agency. It is a public corporation. Who is the CEO, Chief Executive Officer of this corporation? All states in all caps are corporations. Who own it? Who is the state of blankety blank and who own it? It is not a constitutional agency, nor is this law constitutional. It is a public corporation. So, question 4. Who is sheriff number 1234567? Jacket number 1234567. And where is your proof of claim? Who is the boss, master? I dare them to say you. Who is the boss, master, authority, or employer of sheriff number 1234567, jacket number 1234567? Now that you know the jacket number and sheriff number, just call it by that, instead of calling it by the all caps name only. Question 6. Does anybody here have a legitimate and perfected claim on McIntosh of the Jean family's private property, personal property, belongings, and or security? Does anyone here have a legitimate and perfected claim on my private property as the real man? Or is this claim only on the straw man? Please prove your claims now or forever hold your peace, which means back off by now. When did sheriff number 1234567, jacket number 1234567, begin working for the state of whatever state of Florida, Incorporated, your county, Palm Beach County Sheriff's Office Incorporated, etc. Incorporated, the accuser Incorporated, the clerk and comptroller Incorporated, the United States Intercorporation, or the United States Incorporated, England Incorporated, the Barcode Incorporated, the U.S. Navy Admiralty Incorporated, the U.S. Army Maritime Incorporated, or the accuser that compels him to perform. So in other words, when did sheriff number 1234567 begin working for the state of Florida, blah 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 blah, that compels him to perform? Prove your claims on and for the record with prima facie evidence submitted under penalties of perjury and submitted for investigation. Question 8. At what pay rate does sheriff number and jacket number 1234567 get paid? For example, $10 per hour, $3 per hour, 10 cents per minute or what? Prove your claims, because every employee must be paid. They must be paid. And a worker is worthy of their wages, and $6 is minimum wage according to their law, which don't apply to me. So question 9. Does sheriff number, etc., get paid based on a monthly or yearly salary? Or does he or she get paid based on a week-to-week based payroll? Or does he or she get paid under the table by check, Federal Reserve notes, fiat dollars, gold, silver, and or diamonds, or what? State your claim. The sheriff number 7 get paid based on a monthly, yearly, weekly, or under the table salary or payroll. So salary versus payroll and pay rate value. State your claim. What was the alleged principal defendant, McIntosh the Jean family, aka sheriff number 1234567, on the job? Was the alleged principal defendant on the job while the alleged incident occurred? And can you prove that sheriff number 1234567 was at the alleged scene? So was the alleged principal defendant, which is not the injured third party intervener, but the principal target, on the job, in other words, working for the state, while the alleged incident occurred? And can you prove that sheriff number 1234567 was at that alleged scene? And that you were sure that you didn't, and you were sure that you did not see the natural, living and breathing man called McIntosh of the Jean family, or whatever, your first name of the last name family, called man. So prove that the natural living man was not there, and the principal defendant, sheriff number blah blah blah, copywritten and trademark entity, was. So prove that it wasn't you there, the natural man, because it was you, the natural man, there, not that entity. You're trying to tell them that they injured a real man there, not no fictitious sheriff that was on the job. So I said, was the principal defendant on the job while the alleged incident occurred? And can you prove that the sheriff was at the alleged scene and that you are sure that you did not see the natural living breathing man? Prove that the natural living breathing man was not there and the principal defendant was. So if sheriff number blah yada yada is a true sheriff and or officer, servant of the state of Florida's statute-based private corporation. So if sheriff number 1234567 is a true sheriff and or officer, servant of the state of Florida's statute-based private corporation, can you prove that he or she properly filled out an IRS 1040 form or a 1090 OID form or a worker's IRS W4 form to prove that he is governmentally employed by the state of Florida? By the way, this is a taxable event, and it would be a federal crime to not report and register new state employees with the IRS Internal Revenue System. Are you paying your federal taxes on time? Question 13. Who are the natural and real parties in this case, event, and venue, other than me? Question 14, and they must respond to this. They won't be able to. That's what you want, so you can get that default judgment and take off all their shields and immunities. End up filing liens and levies on them and their property and bonds and accounts, just like you stated, personal and private. So question 14, did you get the copyright owner McIntosh of the Jean family, the natural living man's written and notarized consent, approval, authorization, and signature before you created a fictional corporate identity with the name, copyright, and trademark name McIntosh Jean? Prove your claims on and for the record. Question 15. Did you know that under your Title 17? Oh, pardon me. So did you know that under Title 17 of your United States Code, Section 501, copyright infringement is considered a crime? And under Title 17 United States Code, Sections 502, 504, 506, and 505, I am eligible for injunctive, financial, equitable relief. Yes or no? So did you know that copyright infringement is considered a crime, and I am eligible for injunctive relief, equitable relief, financial relief? Yes or no? Ignorance of the law is no excuse. Not for us two or me. We're not spared. We're thrown under the bus daily because we lack the knowledge and light and the truth we need to stand boldly and firmly as we should and ought to. In the name of the Holy Spirit and Christ Yahayasha, through the Father Ahaya, the Creator of all things. Barayashayat, Barayashayat, Barashit, in the beginning. So question 16, under your Title 42 United States Code, Section 1982, property rights, under their law called property rights, states that all members of the United States shall have the same right in every state and territory to inherit, to purchase, to lease, to sell, to hold, and to convey real and personal property. Therefore, I have the right to be paid before you use my private trademark and copyright name, copywritten and trademark name Macintosh Gene. And no one online here today watching this have my permission to use that name without my consent. You have been warned. This is a public announcement. So a worker is worthy of his wages and worthy of his hire. These are the terms and conditions of my stuff. What is thy neighbor's? Question 17. Was there a properly executed warrant for the arrest of the natural living man, also known as Macintosh of the Gene family? If so, prove it on and for the record. Question 18. What is the definition of jurisdiction according to plain and simple English? 19. What is the definition of jurisdiction according to the foreign language called legalese? The foreign language of legalese, or according to legalese, what is the definition of jurisdiction? In other words, Black's Law Dictionary. 20. Who is the BAR, the barcode? Are they foreign? Are they domestic? Are they alien? Are they native or what? Verse 21 or number 21. Question 21. If you are foreign to America, the land and republic, and you are not a citizen, a member of the land of America or the states united for America, where are your green card? Where is your green card, visa, passport, identification, and credentials to be on my land, acting as my authority, master, and leader, without my consent and or contract existing between us? Where are your credentials to be here on my land? Hey, you might be Mexican, you might be Haitian, you might be an illegal immigrant with no delegated authority whatsoever. So question 22. It is my understanding that the Bar Association, the British Admiralty Regulation, or the British Admiralty Rule, or British Admiralty Regulus Association, is a trade organization, a labor union promoting their own private legal profession. their own private legal fictitious profession. That's why I say I don't give legal advice. I don't give fictitious advice. A major conflict of interest. How the heck this is a business in your own private legal profession, not of the land, not of God? What? It's a major conflict of interest, like serving the second master. Let's untangle ourselves. The Most High is not a author of confusion. There's a conflict of interest in this case, a stumbling block, an error which cannot go unnoticed, that is meritless and dishonorable. Matter of fact, it's perjury and treason against their own oath and promise to uphold and protect truth. So it is a major conflict of interest because it is interfering with my private matters without my prior written and notarized permission, consent, and or contract. This is nothing more than a union of local mercenaries, a union of them in their local, county, inferior courts, military personnel for hire, carrying a foreign title of nobility, and operating under the disguise, the guise of the judicial system, which means justice system. Judah, justice. Judah, Yahayada. Disguise of the judicial system. The Judah system, which has vested pecuniary interests in the proliferation of its members and the proliferation of their employees. So they work together under disguise, and their local mercenaries promoting their own private legal profession, which is a trade organization or labor union called the Bar, who is doing this without credential. They got no credential. They're not your master or authority. They're acting like it. No contract is existing between you and that trade organization. And if they are foreign and working under a foreign title of nobility, foreign and guise, where is their green card, visa, passport, identification, and credentials to be acting on your land? Where is their credentials? And if they don't get what I mean, what does jurisdiction mean to their foreign language in their book? And what does it mean in plain English? It means the same thing: power, authority, dominion, which mean contract, consent, and authorization. They don't have it. So they're working and have vested pecuniary interest in the proliferation of its members, employees. So a bar card, a British Admiralty registered card, is nothing more than a certificate of admission, a receipt of admission that they entered into a group as a British esquire, not of the state. They're granted special property right to practice law in letter patents disguised as a certificate of admission. So it's in letter patents disguised as certificate of admission. So trademark and copyright letters disguised as certificate of admission, granted special property rights to practice law. They're all practitioners. Even the judge, he's a lawyer. He's of the bar. You cannot practice law from the bench, and all county judges are practitioners. We all know that the Supreme Court is the only true court in America under the authority of the Constitution of America. Inferior courts are purely based on special visitation and special appearance, and never a general one, unless one submits and surrenders to such illegal activity, which I do not consent to. I discharge all charges levied against my trust account, the straw man, in accordance with my remedy and cure. There is no foundational support for this case to continue, motion, move, process, or progress. Right there, I should have just ended it, but I continue. So number 23, question 23. The legal fiction. Hold on. The legal fiction, Sheriff 1234567, jacket number 1234567, was never at the assumed place and never could have been there because it is a legal fiction, straw man, and have no mind, consciousness, or soul like I, the natural living man, am endowed with naturally. Naturally. Naturala. YASHALIGHTS. So question 24. Therefore I, the natural living breathing man, conditionally accept your claims and charges, if and only if you can produce the evidence that I made an order deemed chargeable. You go to McDonald's, you make an order, hey man, please take your order, you got big large fry, and that's it. They charge you, what are they charging you for? For what you ordered. So what order have you made that is deemed chargeable? Well, sir, you ordered a large fry. Oh, okay, you're right. So I conditionally accepted your claim, so now I accept your claim that I owe you for the fry. And you proved it with evidence. You even have it on audio and tape that I ordered the fry. That's deemed chargeable. You made an order, you gonna get charged. Or unless they're trying to talk about charging up a battery. Are you a battery? Aren't you living, breathing, natural, with a soul endowed with natural, unalienable rights? Are you out of birth? Are you dead? Are you legally fictitious? Are you a sheriff? Are you a contracted under statute law? So how are you deemed chargeable if you didn't break anything? We're chargeable if we break the Most High's commandments. That's deemed chargeable because we broke the order. Now, if you didn't go to McDonald's and they forced their way on you and say, oh, you made an orderable deemed chargeable, which means we're going to charge you with a charge. You know what? Maybe we're human. Maybe I forget. So I conditionally accept your claim that I had made an order deemed chargeable. If and only if you can produce the evidence on and for the record. And that's what we're doing, conditionally accepting it and turning the ball game on them. Twisting the court around on them, using their stuff, their laws, our laws, and the laws that govern all that is and be against them, invoking the spirit of truth within this home. Amen. So in other words, what did I order that you are charging me for? I did not receive anything of value, fair value, whatsoever. And if I did, please prove your claims on and for the record with admissible evidence, admissible proof. I've wrote this stuff, so it's like many ways I could have stated it. So, question 25. A lawfully binding bilateral contract, which means it's a unilateral contract runs one way. A binding and lawfully binding bilateral contract running two ways, both ways, must have three essential parts. Two people must make an offer. One, two people must make an offer. Two people must make fair consideration or give fair value or give consideration. Hey, I'll give you this for that. Hey, I'll give you this for that. You know, to negotiate. And three, to consent to the deal. That's a deal. And that's the process of making the deal. They do that to you by accident, but through unilateral contracts, not bilateral. Because you don't make your own offer when they give you a ticket. There's no consideration or fair value in it for you. They're getting paid from the ticket, which is a contract. And you barely consented with your own free will, deliberately and consciously. So, furthermore, a lawfully binding bilateral contract must be entered into consciously, deliberately, and willingly, with offer, consideration, and consent, with full disclosure. Any non-disclosure deems the whole document voidable. Any bit or a tad bit or blemish of lie or fraud or perjury is enough to cancel the whole thing, to make it all null and void, and to make you into default right away. And you will be punished according to the law of true righteous judgment, which I execute with the blade of my words. It's like they're biting at you, yum, 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 ganashing at you with the sword. So it must be entered deliberately and willingly as well as consciously, with full disclosure and with zero force, zero coercion. Coercion means force and manipulation. Zero manipulation, zero deception, zero lies, and zero fair tactics. If you don't do this now, you're going to jail. Get on the ground. Get on the ground now. Now, blah, blah, blah. It's fair tactics, terrorism, coercion, force, unlawfully, not deliberately done, not truly conscious because you're scared, not willingly because you want to go home and they won't let you go unless you signed it, and it's not even bilateral. These people are breaking the law. May the Spirit of truth reveal all things to us. So prove your claims on and for the record. So why are there financial interests involved in this case if this case is not a commercial venue? Question 27. Is there a true bill, in other words, hospital bill, property damage bill, or any type of bill, a contractual based bill, receipt, bill of exchange, or etc., or certificate, or receipt to validate your claims and charges? Because if there is, show me it. If there is a true bill, some type of receipt, show me it. Prove it on it for the record. Okay, we'll address that. We'll address that now under the laws of the truth, under penalties of perjury now. So how did these costs occur? Was there deception involved in these costs? Any usury or anything like that? So question 28. Where did the charges come from? And how did you come to that conclusion? They must answer these things before you start talking about the case. You have all these questions to ask. And you shall receive. Seek, and you shall find. Knock, and it shall be answered. May the Holy Spirit descend upon me today through these words that I speaketh. Rawak Kwadash, Halalahaya Bahasham, Yeshaya, Waharawak Kwadash. Kowam Yis-RoyAl, O mighty nation of Zion. The race of the Hebrews, IBARAYATH, YASHALIGHTS. May my people be set free. Spread this. Spread the word. Declare it on the rooftops. Announce that redemption has come. Question 29 or statement 29. In our Holy Bible, Quadash book, Quadash Dabar Quadash, the word holy. It states in Exodus chapter 23, verse 1 to verse 9. Thou shalt not raise a false report. Put not thine hand with the wicked to be an unrighteous witness. Thou shalt not follow a multitude to do evil, which means don't lie, and don't follow the multitude to do evil. Neither shalt thou speak in a cause to decline after many, to wrest judgment. Rest mean to twist judgment, like you're wrestling. Rest, to twist judgment, or flip it around, or changing the real owners of the game, the real right of due course of power, holder of due course of power. I am the holder due course of power over my being. In the name of the Most High Power, I am that I am. It is what it is, and you are who you are. Those who are the children of the Satan, of the devil, they never knew the truth and never will. It's not in them. The truth is light. Light don't bring you the truth. Truth brings you the light. It exposes things. I'm exposing that your light is not truth, and you claim it's light. That's false advertisement. Where's the truth in your judgments and your claims? This is all full of truth. Where have I lied so far, people? Please leave a comment. And there won't be, because I'm telling the truth, and it's the domineering truth. It dominates. So thou shalt not twist the judgment of thy poor in his cause. Cause and effect. Verse 7. Keep thee from a false matter, and the innocent and righteous slay thou not. For I will not justify the wicked, and thou shalt take no gift, no bribery, no bond money, all that junk. They shouldn't be getting paid to be referee. It should be their desire to do righteous judgment. So thou shalt not take no gift, for the gift blindeth the wise, and perverteth the words of the righteous. And that's what they're doing. They're perverting our words, and the gifts are blinding them. Verse 9. Also thou shalt not oppress a stranger. So that was in Exodus chapter 23, verse 1 to 9. So question 30. What is law and what is not law? And who? So what is law? What is law? What is law? Where does that word come from? Lawya? Or lawa? Lawe? Lawai? Lawai, Levites, like Moses, the lawgiver. What is law and what is not law? And who and or what told you what is law and what is not law? Please explain. I'll tell you what is law: the word of God Almighty, the creator of heaven, the earth, and the sea, and all things that dwelleth in them. The one who planted the stars in the sky and created both black and white people, black and white, and created both pale skin, light skin, and dark skin Hebrew Israelites. Pale skin and dark skin people. He created all tongues, all languages, all traditions, all customs. He's in charge of both the left and right hand like one body, and we're connected to the branch of Christ, the only true vine. And the Most High Father is the planter of it. How do I know? Because the Bible told me so. That is the law. That is who and what told me. Who? Ahaya Shurahaya. Keep his laws, statutes, and commandments. He tells us this. That's my jurisdiction and authority. It's not me who speaketh, it is the Most High. So, what is law and what is not law? And who and or what told you what is law and what is not law? Please explain. Question 31. What is a true crime according to rerum natura? In other words, according to the natural world, where things are real and not imaginary, fairy tale, fictitious, made up, straw men, boogeymen, ooh, terrorist fear tactics. And what would be a reasonable punishment for such natural crime? If I took something, or if I didn't keep my promise, things like that. There shouldn't be no extra interest and tax and all this stuff. Man, y'all chill out. Y'all eat in my pockets. Question 32. What is a plea? And why would I ever plea? In other words, beg. Or enter a plea, beg guilty or beg not guilty. If I didn't break any real and natural, common and universal law or laws. So why would I ever beg guilty or not guilty? To what law? No contender. So question 33. What would I, the natural man, be guilty or not guilty about? You will need the subject matter jurisdiction to properly answer this question. The subject matter jurisdiction. Question 34. The principal party, trademark and copyright name, Macintosh Gene, all caps, also known as sheriff number 1234567, jacket number 1234567, does not exist. This entire event is all fairy tale, fantasy, delusional, crazy, a waste of time, deceptive, unrealistic, artificial, and completely treacherous, and there is no proof to support the contrary. This is all make-believe. Make it, believe it. Wow, this is Make believe, even all this right now is make believe. Even the computer you're watching this through is make believe. Or the audio you're hearing it through, make believe. Everything's make believe. That's the job of the mind and the imagination, which is a tool, not God, but it's a tool to make believe, to create, to build or destroy. That's what the imagination is, but too much people are lost in it. They're lost in their imagination, vain deceit, and wanting vain glory, wanting to get credit for doing bad things, to the point they made up Nobel Peace Prizes to people who never kept any peace. They're tricking themselves, calling what's good bad and what's bad good. They're completely backwards and upside down and moving forwards in whatever direction they're in now, upside down, backwards. They're not moving the real forwards, which is backwards and upside down. If you start moving backwards now and upside down, you'll be moving forward and right side up, because today's society is backwards and upside down. Thinking backwards and upside down is forward. It's a false forward. It's a true backwards and a false forward. So flip everything right side up again and reverse yourself and go forward the right way, the righteous way, and you'll be in the true forward. And the false backwards, because it's not the true backwards, it's the true forward. The narrow path that lead to heaven, because the path that lead to hell is broad. So let's continue. Most of these people going straight to hell for what they did. They're going to pay, I promise you that. Amen, I affirm. So if you assume, question 35, if you assume that me, the injured third-party intervener, or the principal defendant, trademark, copyright name, Macintosh Gene, sheriff number, blah, 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 gave you or anybody authorization to be our power of attorney, POA, or authorized representative, authorized rep, which you should always put on your documents, then me and or him demand for you to drop this case now. If you were our power of attorney or authorized representative, or we terminate such POA and authorized rep contract on and for the record, if such POA and or authorized rep contract ever existed between me and you and him, and or us and you. Because me and him is not the same. So I don't know if a contract exists between me and you, the real man and you, or you and him, you know, and you got the wrong guy, I'm in the middle of this stuff, or us and you, whether you're saying me and him is together and you are power of attorney of us. All that is terminated. So question 36 or demand 36 or whatever, number 36, on and for the record, we declare that all power of attorney and or authorized representative contracts not written and approved by us, in other words, me and my client, are all null and void, nunc pro tunc ab initio. You are fired as of now for not meeting my requirements of a responsible and competent representative, POA, and or trustee. Number 37. Who does the United States Constitution apply to? And who does it not apply to? Because I'm not under the Constitution of the US either. I'm Hebrew Israelite anyway. I was taken here on ships. Luckily, I'm Haitian. We all been ran into exile in the four winds and the four corners of the earth. Now we're being united. Koam YASHALIGHTS under Yahaya Shai. Ahaya Bahasham Yahaya Shai. Yahaya Bahasham Yahaya Shai. So number 38. What is a statute? Who does statutes apply to? And how does a man or woman get into a statute-based, contractual, and consensual, written and notarized agreement? By contract, consent, written and notarized and agreed. Number 39. Are statute-based laws private, public, corporate, natural, or universal? Or please explain otherwise. Number 40, according to your constitution for the state of Florida, or according to your state constitution, wherever you're at, incorporated, Article 2, Section 5B states that each state and county officer, before entering upon the duties of the office, shall give bond as required by law. Bond, contract, agreement, oath of office, required by law, and shall swear or affirm, I do solemnly swear or affirm that I will support, protect, and defend the Constitution and government of the United States and of the state of Florida, that I am duly qualified to hold office under the Constitution of the state. Duly qualified to hold office under the Constitution. I'm not duly qualified, so I do not work for the state. So in that I will well and faithfully perform the duties of title of office, title of nobility, on which I am now about to enter. So help me God. And this is what they get into when they invoke God's name, using his name in vain on the oath and taking a bond, which they solemnly swear or affirm. So, number 41. Can you prove that sheriff number, etc., made such an oath, promise, or commitment as such? 42. According to your Title 4 United States Code, Title 4 USC, you require an oath of office. Public Law 31H. The Uniform Justice Court Act. The Uniform Justice Court Act, look that up, requires an oath of office. So does the state requires an oath of office. And only a competent Title III United States judge with competent jurisdiction can preside this case. She must be a Title III judge after taking a Title IV oath. And if you're under state of Florida, Article 2, Section 5B. So you want custom make it to your own state. Very simple. Do some research. Do your due diligent research. So only a Title III United States judge with competent jurisdiction can preside this case, according to your United States Code. And are you a Title III United States judge? And did you take an oath of office according to your Constitution for the state of Florida, incorporated? In other words, Article 2, Section 5B. I demand that you prove your claim. In other words, your oath of office. On and for the record, so we can validate your claims, or I suggest that you dismiss this case immediately. Or you will be exposed and charged with capital treason under your United States Code, Title 18, Section 2381, treason. As an imposter, perpetrator, white-collar criminal, impersonator, and perjurer. Number 43. Under your state of Florida, Article 1, Section 20, Private Corporate Statute, submit your oath of office on and for the record for investigation and examination. Under your Article 1, Section 20. Under number 44. Under your Title 28 United States Code, Section 453, Oaths of Justices and Judges. You must take an oath of office to be elected, nominated, and voted for into office. And according to your Title 28 United States Code, Part 1, Chapter 21, Section 454, practice of law by judges and justices. Any justice or verbatim, word for word, quote unquote, any justice or judge appointed under the authority of the United States who engages in the practice of law is guilty of a high misdemeanor. So they broke a couple of laws already. It also states in your Title 28 penalty So it also states in your Title 28 United States Code, Part 5, Chapter 115, Section 1746. Unsworn declarations under penalty of perjury. If they don't swear under penalties of perjury, if it's unsworn. So under penalty of perjury, you must take your oath, affirmations, verifications, declarations, certificates, statements, provide evidence supporting facts and or affidavits of truth under penalties of perjury. True, correct, and not misleading. That's why you must put down your document. And that's according to Title 28, Part 5, Chapter 115, Section 1746, and it's called unsworn declarations. So it must be sworn under penalties, true, correct, and not misleading. All oaths, all bonds, all affidavits. Every bond has one. Every bail bond, which is the devil's bond, Bailey's bond, have them. So they must state it on and for the record and prove it. And it should not be misleading. And place it on public record for investigation. We're going to conduct a public investigation, a civil investigation. We have the right to even enforce public arrests, a civil arrest, although I'm not a civilian of the state. It would actually be an act of war if I did it, because I'm a Hebrew YASHALIGHT. IBARAYATH YASHALIGHT. IBARAYATH YASHALIGHT. So place it on public record for investigation, because that's public document, public sworn oaths, and the state is a public corporation. So number 45, have you done this yet, or has sheriff number etc done this yet? Which mean I took an oath of office. No, I haven't, and no, he haven't, and they better have, because they claim they judge. So prove your claims, or forever hold your peace, which means drop this case now, or you will be committing a crime. You will be exposed. Number 46, under your state of Florida statute-based contractual laws, it states in section 35.178 that, quote unquote, a state shall not be immune under the 11th Amendment to the Constitution of the United States, shall not be immune under the 11th Amendment from an action in federal or state court of competent jurisdiction for a violation of this act. And tort action, section 768.28, you waive all your sovereign rights and immunities by becoming a British Admiralty registered esquire, agent, mercenary, operating under a special foreign title of nobility for the Bar Association. In tort action, section 768.28, and under the state of Florida statute, section 35.178. So you cannot serve God Almighty and men both at once, and you cannot protect and serve America and its enemies both at once. You cannot enjoy the rights of being an American official and British esquire both at once. That is treason and piracy. Therefore, who do you work for? America or England? Do you know? So 47, according to the United States of America, the land's constitution, and clause 3, it states that the Congress shall have power to regulate commerce with foreign nations and among the several states. That's United for America. And clause 17, the District of Columbia, D.C., is federal property, according to American Constitution. And in clause 17, Congress shall have power, dominion, sovereignty to exercise exclusive legislation for their little club, for their group, in all cases whatsoever, over such district not exceeding 10 miles square. So if they're breaching my will, They're exceeding their 10-mile square distance between the people, the real people, the natural people, and their fictitious thing. They need zip codes to drag you within that 10-mile square. So number 48. This court is a contractual-based statutory court of commerce with international jurisdiction. So it's a contractual-based statutory court of commerce, a court of commerce with international jurisdiction. In other words, you are attempting to function outside of your 10-mile square region of the District of Columbia. That is fraudulent because it is operating outside of its geographical venue. Therefore, you are false advertising and misusing the name U.S., USA, United States, federal, court, law, and rules to indicate a federal agency that you are not, which is a Title 18 USC Section 709 crime, false representation, perpetration, false advertisement. False advertisement is a crime. False advertisement is a big crime. It's deception, it's fraud, it's malpractice. Number 49. The United States Incorporated has been in bankruptcy since 1938, and it and its trustees, sureties, and bondsmen. Oh, we the people of the States United for America, our gold and silver, which they borrowed from us and lost in their undisclosed schemes and plots against the very people who elected them and lend them credit. For example, Session 1, Chapter 48 and Chapter 49 of the 73rd Congress, all plots and schemes. Executive Order, all plots and schemes. Martial law, all plots and schemes. House Joint Resolution 192 of June 5th, which was the abrogation of gold, all plots and schemes. 1933, June 5th of 1933, HJR 192, House Joint Resolution 192. This is going to help you out a lot in discharging cases. This 1990 in House Joint Resolution 192 of June 5th, 1933. H.R. 1491. Public Law 1. 48 Stat 1. Public Law 10. Chapter 48 Stat 112. Public Law 73 through 10. Or 73-10. 40 Stat 411. Trading with the Enemy Act, TWEA. All these are schemes and plots against the people. Of October 6, 1917. 114 Stat 1470. Public, you should look these up on Yahoo or Google. Public Law 106 -386. October 28, 2000. Administrative Procedures Act of 1946. The Bar Act of 1939, the Uniform Commercial Code of 1972, which is the supreme law of the land over the banking system, the Law of Merchant Act 1870, Contract Law, and the Libra Code of 1853, as well as the Bill of Exchange Act, the International Bill of Exchange Act. So 50, under your state of Florida statute, Article 13, Section 18, there cannot be a conflict of interest in this case. There cannot be a conflict of interest in this case. There cannot be a conflict of interest in this case. In other words, the judge is the referee/trustee. Period. I, McIntosh of the Gene family, the natural man of Ahaya Almighty, am the beneficiary and secure party creditor. Period. I am the creditor in this event. The principal defendant is the fictitious entity. In other words, sheriff number 1, 2, 3, 4, 5, 6, 7. Period. That's the proper perspective and everything in its proper place. That's order in the house. And the accuser is the accuser. Period. Number 51. The judge cannot be a lawyer for the beneficiary. and the lawyer for the defendant, and the lawyer for the accuser, all at the same time. Nor can the judge play as defendant, and play as beneficiary, and play as accuser, and play as jury all at once. That is what we call a conflict of interest. Nor can they be friends or buddies, like the church and state. That's gonna cause problems, and it happened already. So carrying on. So verse 51, number 51. The judge cannot be a lawyer for the beneficiary, defendant, and or the accuser all at once, at the same time. Nor can the judge play as defendant, beneficiary, accuser, and jury all at once, because he might as well just stay in the court by himself and make believe. Play with yourself. Go masturbate. You know what I'm saying? Might as well go entertain your own brain. Because if you're going to be defendant, beneficiary, accuser, and jury all at once, I don't need to be there. And if I'm there, I am who I am, you are who you are, he is who he is, she is who she is. What is your name, status, and nationality on it for the record? I need to know. So does the record do. So that is a major conflict of interest. Major. Plus, everybody in the courtroom is working for the state of Florida. Corporation. So all the power of attorneys, the bar people, all of them working for each other. They're all working for the state corporation. They're all part of the same business. That's a conflict of interest. That's monopoly. They're monopolizing the industry. They're monopolizing the land. They own everything. Doctors, sheriffs, police, Illuminati, Masons, presidents, chiefs, they own every freaking thing. That's a gigantic conflict of interest. And they working with churches and work for the Vatican priests of England as a foreign esquire, foreign agent. They're pirates. Literally in Admiralty. America has been seized. So everybody at this event are buddies, friends, and co-workers working with each other. Remember, they work for the proliferation of their employees and members, as well as conspiring against the people they swore to protect and serve faithfully, which means they're swapping you back and forth, making deals with the judges and all that which they know, giving eye signals and winks and certain hand fingers gestures like now. You know what I'm saying? And the power of attorneys of your enemy is working with your power of attorney. That make no sense. Like, why the heck is my attorney friends with your attorney and they friends with the judge? Like, hold up, man. And it seems like they're against me. It's all aimed towards you. That's fraud. That's fraud to injure you. Equality before the law is paramount. Paramount. Section 18, State of Florida Statute, conflict of interest. This is what they say. A code of ethics. This is a code of ethics for all state employees, sheriffs, those who do have real jackets, police jackets, and have a police jacket number, sheriff number. A code of ethics for all state employees and non-judicial officers, prohibiting conflict between public duty and private interests shall be prescribed by law. So it's prohibiting conflict of interest between public and private, public duty and private interest. Number 52. Under your Title 42 Trust in a State, Florida Trust Code, Chapter 732. Go to the Trust in the State codes of your state. Trust codes. Section 736.0801. Duty to administer trusts. Chapter 736, Section 736.0802. Duty of loyalty. So under their law, duty to administer trust, and their law, duty of loyalty. Chapter 736, Section 736.0809. Under their law, control and protection of trust property, my social and all that stuff which they're trying to extort from. Your social is connected to a bank account. The Federal Reserve Bank because they owe you money, and they gave you unlimited credit according to HJR 192. So you can discharge all your debt with your signature and stuff like that. And there's more to it. I can't tell you it all in these videos, but look at all my videos in the websites that I gave you earlier. And you can email me at godlivesinourheart@hotmail.com, or Skype me right now on at Archangel Macintosh, archangel.macintosh. So control and protection of trust property, chapter 736, section 736.0702, and Florida State Statutes 817.02, obtaining property by false personation. Now if they want to, they can go into that, but under those laws, they are limited and restricted by their own laws, codes, statutes, and ordinances from lying, cheating, and stealing. Lying, bearing false witness, cheating, adultery, and stealing. From 1, the beneficiary, in other words, the benefiting party, the benefactor of the Sesticue Trust, and 2, the creditor, in other words, the lender. So you can't steal from the creditors and the lenders, and or the trustor, in other words, the person granting property right or corporate rights or fictional rights, in respect to the beneficiary, the benefiting party. So your job is to protect the people you serve. Therefore, I accept your oath of office and your promise to protect and serve us, we the people of the land called America. So 53, the 11th Amendment under the United States Constitution reads as follows: the judicial power of the United States shall not be construed to extend out of the 10-mile square district to any suit in law or equity commenced or prosecuted against one of the United States for America by citizens of another state, so or by citizens or subjects of any foreign state. So a citizen from a foreign state cannot sue someone from a foreign state. You must be domestic. You must be within the same land. Why do you think they call certain things like domestic violence, domestic threat, all that stuff? They're trying to say you're within the District of Columbia, within the 10-mile square distance. That's a lie. So it shall not be construed to extend to any lawsuits or equity, which mean money, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. So they cannot be, they need jurisdiction, in other words. They need jurisdiction. That's what that means. So on December 9, 1945, International Organization Immunities Act, the International Organization, like a criminal organization, Immunities Act, relinquished every public office of the United States to the United Nations. That's what they did. The United Nations. And they became the North American Union, one of the 4 beasts that bow before the throne of Abba Alahaya, Bahasham Yasha, Hawashai, Hayashai. This law makes all public officials foreign citizens, barring them from judicial power, from court power, justice power. All public officials are administrative agents of the United States Corporation. They have no judicial power whatsoever. Number 54, 22 Code of Federal Regulations, CFR, 22 CFR, section 92.12 through, 92.12-92.31. FR heading, Foreign Relationship with foreign people, states that oath is required to take office. Title 8 USC 1481 states, once oath of office is taken, citizenship is relinquished. Once you become a member of the foreign people in the foreign relationship, you give up your sovereignty and the sovereignty of your state. And they need our permission to do that, and they didn't. But that is the Code of Federal Regulations, CFR. So they state that oath is required to take office. Once oath of office is taken, citizenship is relinquished. Thus, the oath taker becomes a foreign esquire, a foreign entity, an officer, and that's what they're trying to charge you as. That's identity theft. That's fraudulent, frivolous, embezzlement, extortion. So you become a foreign entity, an agency, like on your case details paperwork, or state, a foreign state in a zip code. So that means every public office is a foreign state, even all public subdivisions, every one of them, all counterparts are all foreign states under the Foreign Relationship Act, where America relinquished their sovereignty to the United Nations and joined up with Canada and Mexico to become the North American Union. So, in other words, every single court is considered a separate foreign entity, inferior, not competent to know the law. Title 22 USC, Foreign Relations and Intercourse. Chapter 11 identifies all public officials as foreign agents. Amendment 9 of the United States for America prohibits foreign states from adding to or subtracting from the common law American Constitution. Amendment 10. Two constitutional contracts cannot be in conflict. Thus, the American Constitution prevails. It is the supreme law of American land. And God Almighty's law, Ahaya's law, is the law of the universes. The laws of existence and its creations. The laws are the same. Do unto others what you want others to do unto you. So the 11th Amendment also makes a foreign state separation from the position of the public. So the 11th Amendment also makes a foreign state separation from the position of the public office positions to throw off the people. So the people have 11th Amendment immunity because there is no judicial power of the inferior courts, your county courts, your circuit courts. It's a circus, a ruckus, babble, gaga goo, Babylon, ancient Babylon, witchcraft, sorcery, voodoo. We summons you. I cast you out in the name of Christ Yasha. Yahayashai. So when the people have foreign sovereign immunity, because we're foreign and they're foreign, we're non-domestic without the U.S., all judicial power of the inferior courts comes from the Judiciary Act of 1789. That's where the inferior courts get their power from. As did the Attorney General position, AG. Judicial power comes from Article 3, Section 2 of the Constitution. So it's the Constitution that grants the judicial branch of the government power. There's the judicial branch, executive branch, and legislative branch. Legislative make the law, judicial execute it, which mean they give a remedy for breaking the law or justice, or they enforce the penalties of the law, which is judicial or law enforcement, and executive would be the enforcers, the law enforcers, because they execute it, they enforce, they execute. Judicial is a court for those who break the legislative laws. So legislative, executive, and judicial. So judicial power comes from Article 3, Section 2 of the Constitution. These laws never apply to me and my people. The 11th Amendment removed all judicial power in law, equity, treaties, contract law, and the right of the state to bring suit against the people because they're fictitious. That's what immunity is. Municipal, county, or state court lacks jurisdiction to hear any case under the foreign state definitions coming from the 11th Amendment under the U.S. Constitution. This jurisdiction lies with the United States District Court under the Foreign Sovereign Immunities Act, FSIA statutes, pursuant to Title 28 U.S.C. 1330.2. The fact that public officials are not citizens, but rather foreign citizens, all of the cases must be dismissed because the court lacked and lacks jurisdiction to enforce judicial power. This court is an administrative court and not a criminal court. It is an administrative court. In other words, no judicial power makes this court an administrative. No judicial power makes this court an administrative court. Also, this following act proves that this court is an administrative agency, although the judicial power does not give administrative power. That's a different branch. Also, this following act proves that this court is an administrative agency. The administrative, the Administrative Procedures Act, Title 5, the Government Organization and Employees Administrative Procedures Act, Part 1. So that proves that they are an administrative agency. So number 55, according to your Title 18 United States Code, corporate delicti, quote unquote, there must be an actual injured party for a crime to exist. Who is the injured third party in this case? The natural free will man endowed with natural unalienable rights. He is the injured party, injured third party intervener, not the injured principal party, not the injured defendant party, but the injured third party intervener. Well, there's a crime now because I am injured. But according to Code of Federal Regulations, CFR, Title 27, Section 72.11, all crimes are commercial. Verbatim, all crimes are commercial. So, number 56, therefore, who is the real injured party in this event? So who is the real injured party in this case, other than McIntosh of the Jean family, the natural living man? Number 57, is there a commercial event? Is this a commercial event? Is this a criminal event? Or is this a contractual event? In other words, is this a commercial, criminal, contractual event, or a natural, common law, court de jure, court of jury, of truth? In other words, is this a natural common law court of competent jury, jurisprudence, and competent jurisdiction? Please explain. They won't be able to answer that. Number 58. Under your Title 18, Section 241, United States Code, conspiracy against rights, and under Title 18, Part 1, Chapter 13, Section 242, deprivation of rights under color of law, it clearly states that if two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercises or enjoyment of any right or privilege secured to him or her, especially by the Constitution, shall be fined under this title, or imprisoned not more than 3 years, or both. If such acts include kidnapping or an attempt to kidnap, you weren't arrested, you were kidnapped, I was kidnapped, or an attempt to kidnap, shall be fined under this title or imprisoned for any term of years or for life or both, or may be sentenced to death. The wages of sin is death. So number 59. Are these charges a conspiracy against my natural higher God-given rights under color of law? And are you or your affiliates attempting to deprive me of rights? Which is all Title 18, deprivation of rights, conspiracy against rights, and color of law. Yeah, that's it. Deprivation of rights under color of law and conspiracy against rights, which we just clearly outlined right here. So are these charges a conspiracy against my natural God-given rights under color of law? And are you or your affiliates attempting to deprive me of my rights? Number 60. If you are not attempting to deprive me of my rights under mask, veil, deception, color of law, in other words, then I demand that this case be dismissed immediately upon failure to state a claim upon which, this should be for failure to state a claim upon which relief can be granted. I demand that this case be dismissed immediately for lack of SMJ, subject matter and jurisdiction. Dismiss immediately because this is the wrong, improper venue. To be dismissed immediately because there's fraud, deception, identity theft, extortion, embezzlement, and abuse of power. Or you and or your affiliates are committing perjury and treason against your own oath of office. According to protect and serve. According to your Title 18 United States Codes, corporate delicti, there must be an actual injured party for a crime to exist. And according to Code of Federal Regulations, Title 27, Section 77211, all crimes are commercial. So, number 61, we're about to pause in a minute and continue in our last video, which will be part 4. So under your Title 42 United States Code, Chapter 21, Subchapter 1, Section 1986, action for neglect to prevent, states that every person who having knowledge that any of the wrongdoings conspired, any of the wrongs conspired to be done, every person who have knowledge that something wrong is about to be done, and having power to prevent it, or aid in preventing the commission of the same, that neglects or refuses to prevent it, shall be committed and liable to the injured party. They're owed the injured party for all damages caused by such wrongful acts which such person by reasonable diligence could have prevented. So in other words, if they do not, it's called action for neglect to prevent. This is a United States code for all U.S. states. Every person who having knowledge that any of the wrongs conspired to be done and mentioned in section 1985 of this title are about to be committed, and having power to prevent or aid in preventing the commission of the same, neglects or refuses so to do, if such wrongful act be committed, shall be liable to the party injured or his legal representatives for all damages caused by such wrongful act, tort, which such person by reasonable diligence could have prevented. So number 62, under your Title 28 Code of Federal Regulations, CFR, Chapter 1, Part 35, Subpart B, Section 35.134, retaliation or coercion, states that no private or public entity, which means foreign esquire, officer, trustee, shall discriminate against any individual because that individual has opposed any act or practice or practice made unlawful by this part, or because that individual made a charge, testified, assisted, or participated in any manner in an investigation, proceeding, or hearing under the act or this part. B. No private or public entity shall coerce, intimidate, threaten, or interfere with any individual in the exercises or enjoyment of, or on account of his or her having exercised or enjoyed, or on account of his or her having aided or enjoyed any other individual in the exercise or enjoyment of any right granted or protected by the state. Any right granted or protected by the act of this part. So anyone who is enjoying their rights, exercising their rights, or aided or encouraged any other individual in the exercise of rights or the enjoyment of rights, or any rights granted or protected by the act of this part, anyone who do that will face charges. Pretty much, they're breaking a Title 8 USC crime code. So this is where we're going to end it. Supreme Court cases. Defense of lack of jurisdiction over the subject matter may be raised at any time, even on appeal. Appeal means to send the documents up to the Supreme Court, the only true and real court. And that's the Supreme Court between Hilltop Developers versus Holiday Pines Service Corp. 478 So 2D.368 FLA 2nd DCA 1985. That's what they call it. So jurisdiction, once challenged, cannot be assumed and must be decided. Maine versus Tihibotut 100S.CT.250. A universal principle as old as the law is that proceedings out of a court without jurisdiction, proceedings, movement, motion, all that in a court without jurisdiction are a nullity, and is judgment therein without effect either on person or property. That's Norwood versus Rainfield 34C 329 ex parte. Giambonini 49P point page 732. So jurisdiction is fundamental, and a judgment rendered by a court that does not have jurisdiction to hear is void ab initio. So that's from in reapplication of Wyatt 300P 132 regarding Cavit 118 P2D 846. So where judicial tribunal has no jurisdiction of the subject matter on which it assumes to act, you see, so they know these words, its proceedings are absolutely void in the fullest sense of the term. That's Dillon versus Dillon 187 P 27.3. So if any tribunal court finds absence of proof of jurisdiction over a person and subject matter, the case must be dismissed. See Louisville vs. Motley 2111 US 149 29S.CT space 42. The accuser bears the burden of proof beyond a reasonable doubt. There's reasonable doubt, but it must be beyond that. So this is the last page we're going to see for right now, and we're going to continue on with the last pages, the bottom 6 pages, actually 5 pages. So a judgment rendered by a court without personal jurisdiction over the defendant is void. It is a nullity. A judgment shown to be void for lack of personal service on the defendant is a nullity. Lack of personal service is having jurisdiction. That's Shramek versus Shramek 17 Con App 2D 573, 576-77, 840 P.2D 55.3 space 1992, Rev. Denied 252 Con point 1093, 1993. So you got to put it exactly as that to find it on YouTube and stuff. So a court cannot confer jurisdiction where none existed and cannot make a void proceeding valid. It cannot make a void proceeding valid. It is clear in well-established law that a void order can be challenged in any court. Old Wayne Mutt, point L. Assault, point B. McDonough, 240 U.S. space 8, 27S point CT point 236 in parentheses 1907. So these are their laws. A court cannot confer jurisdiction where none existed. A judgment rendered by a court without personal jurisdiction over a defendant is void. Where the law is that the proceedings of a court without jurisdiction are a nullity and is judgment therein without effect, either on person or property. Jurisdiction, once challenged, cannot be assumed and must be decided. Defense of lack of jurisdiction over the subject matter may be raised at any time, even on appeal. So I hope you guys learned a lot today. Meet me in the next video, part 4, and let's wrap it up and finish up our affidavit of truth. Hope you guys have a wonderful day. Ahaya Shurahaya Barakata Bahasham Yasha Yahaya Shai Yashaya Yashahaya Ahaya Yasha Ahaya Hayashai Waharawat Kwadash in the Holy Spirit. Aman. Ahaya Barakata, Ahaya Barakata, Ahaya Barakata, Ahaya Tazabawat Barakata. Aman. I affirm this is true, faithful, and not misleading.